Welcome back to Lostash channel. My name is Anton Vialtsin. I'm an attorney in the Southern District of California here in San Diego. And as a criminal defense attorney, I handle all sorts of cases, from DUIs to violent crimes and everything in between. And because I work in one of the busiest border districts in the country, a bulk of my cases deal with narcotics, guns, and immigration-related crimes. So if you've been charged with a crime anywhere in California or Nevada, consider giving me a call and we can chat about your case. But for now, let's focus on a case that deals with the question of what constitutes a seizure under the Fourth Amendment. Particularly, the moment when the individual gives his driver's license to the police. Does that moment change the interaction into a seizure of a person? Well, let's find out. But before we go on, I want to thank you for watching me on YouTube, hitting that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please consider giving it a 5-star review rating. And finally, if you want to support this channel, go to LAWSTACHE.com and purchase one of my t-shirts, the most famous Do Not Arrest This Person t-shirt. Thanks for watching.
Quick message from Lostash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vialtsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lostash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lostash YouTube page. That's LAWSTACHE.
Today we'll be discussing DC Appellate Decision United States versus Carl Jordan. First, let me give you some factual background. 4 plainclothes officers were conducting a drug interdiction at a bus stop. They observed Jordan get off the bus, and one thing that they noticed was that Jordan was carrying only a small tote. Jordan quickly made his way out of the bus stop to the parking lot where he would meet another individual. Before the 2 men would get into the car, officers approached. One of the officers asked Jordan if he was willing to talk, and Jordan said yes. The officer then asked Jordan for his driver's license and the bus ticket, and Jordan provided those. The officer then asked Jordan if he had any narcotics on him, and Jordan said no. So the officer asked Jordan if it would be okay if the officers searched the tote that Jordan was carrying, and Jordan consented to the search. Now, of course, here's a reminder. Never consent to searches. It never helps. And here, after the search was conducted, officers found more than 50 grams of cocaine and a small amount of marijuana in the tote. Mr. Jordan was charged in federal court with possession with intent to distribute of cocaine in violation of 21 U.S.C. 841 and possession of marijuana. Now, you would think that this was a case of consent. And a consent, of course, is an exception to the warrant requirement under the Fourth Amendment. But Jordan makes an argument that his consent was tainted by the fact that he was seized earlier. When he gave the driver's license to the police officers, he says that constituted a seizure because the officers did not return his driver's license. Now, the question, of course, becomes, was his Fourth Amendment rights violated? And to answer that question, we have to look at what constitutes a seizure of a person. The protection against unreasonable seizures extends to seizures of the person as well as seizures of property. Such seizures of person are defined as restraints of liberty caused by either physical force or a show of authority on the part of law enforcement officers. No physical force is involved here, so the encounter can only be characterized as a seizure if it involves a show of authority sufficient to meet the standards established by the Supreme Court. In United States v. Mendenhall, Justice Stewart enunciated the test for a show of authority seizure. A person has been seized within the meaning of the Fourth Amendment only if, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. The Supreme Court revisited the topic of show of authority and seizure of a person many times. And since this test was first established, more cases talked about the fact that we have to focus on the conduct of the police, not the surroundings. Of course, we're often reminded that this is an objective test, meaning what a reasonable person would feel in that situation. but it also has a subjective component because the person has to actually submit to the show of authority. If the person doesn't submit to the show of authority, no seizure occurs. In some, under the most recent cases, a seizure occurs only if, number one, a reasonable person would feel under the circumstances he could not disregard the police inquiries and go about his business. Number two, the restraints imposed upon him result from the police conduct itself rather than the happenstance of where the encounter occurred. And finally, number three, the person actually reacted in a manner consistent with being seized. While the police request for identification does not automatically rise to a seizure, if the documents are handed over to the police and the officers have a reasonable opportunity to review the documents and fail to return them to the individual, it is hard to imagine that any reasonable person in that situation would feel free to leave. But the record in this case is not clear. During the suppression hearing, Mr. Jordan testified that he gave the documents to the officer who then later failed to return them to Mr. Jordan. But when asked 3 times, the officer simply couldn't remember whether he held on to the documents. But he candidly admitted that without Jordan's consent, he did not have any reasonable suspicion or probable cause to detain or search Mr. Jordan. So this case was remanded back to the lower court to determine whether the documents were held on. Now, here are the takeaways from this case. There are a number of takeaways in this case. Takeaway number 1, the Fourth Amendment protects against unreasonable seizures of both person and property. Takeaway number 2 is that if we're dealing with a seizure of a person, that seizure can occur by either physical force by the police or what we call show of authority. Takeaway number 3, when we're dealing with a show of authority, we're asking the question whether a reasonable person would feel free to leave from that interaction with the police. And of course, if the individual submits to the show of authority, a seizure has occurred. And finally, the last takeaway is that if the officers ask you for your driver's license and you hand over the driver's license to the police, the officer has a reasonable opportunity to review the document and fails to return that document to the individual, to you, well, that in that case, a seizure has occurred because no reasonable person in that situation would feel free to leave without their driver's license. I hope you enjoyed this video. I hope you learned a little bit more about seizure of a person under the Fourth Amendment. If you like this video, please give it a thumbs up, subscribe to my channel, and share it with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of my merch, including these Do Not Arrest This Person t-shirts. Thanks for watching.